In New York, under the Child Support Standards Act, the parent that does not have physical custody of the children, known as a non-custodial parent, pays for the support, maintenance, and education of the children. Certain payments for the benefit of the child, such as gifts, clothes, transportation, vacation expenses, or rent, may not be considered child support. Further, the custodial parent in New York is not required to provide an accounting with regard to the child support payment. For the purposes of the Child Support Standards Act, child support is calculated on adjusted gross income. Adjusted gross income is defined as gross income less certain deductions that are permitted. These permitted deductions include certain unreimbursed employee business expenses, maintenance paid to a spouse not a party to the current action for child support, but only if there's a court order or properly written agreement, maintenance paid to a spouse who's a party to the current action, but only if there is an existing order or a properly written agreement, child support paid pursuant to a court order or a properly written agreement to a child who is not a part of the pending action, public assistance, supplemental security income, New York City or Yonkers income tax actually paid, FICA. In order to determine the amount of child support to be paid, the adjusted gross income amount is multiplied by the guideline percentage for the number of children. The child support percentage is fixed as follows: 17% of the combined parental income for one child, 25% for the combined parental income for two children, 29% for the combined parental income for three children, 31% of the combined parental income for four children, no less than 35% of the combined parental income for five or more children. The law provides for a combined limit of $136,000 in income for calculating child support. This limit, depending on the circumstances, may be disregarded by the court. The non-custodial parent must pay his or her pro rata share of the child support. In addition to the child support, the non-custodial parent also pays his or her pro rata share of child care, medical, and educational expenses. For example, if the non-custodial parent's share of the combined income is 70%, then the non-custodial parent will be responsible for paying 70% of these expenses. The Child Support Standards Act states that the court has the option of not following the guidelines if it determines that doing so would be unfair under the circumstances. The court seldom uses its discretion to deviate from the guidelines. The parents of the child can opt out of the Child Support Standards Act by agreeing to a higher or lower amount of child support. To opt out, the parents must sign a written agreement that states that they had been advised of the provisions of the Child Support Standards Act, the amount of child support that it would require, and the reasons why they have agreed to an amount other than that called for under the Child Support Standards Act. Please note that the judge must approve any deviations from the Child Support Standards Act. Due to a change of circumstances, either party may request in family court a modification upward or downward to an order of child support. Usually a change of circumstances is defined as a change in income of at least 10%. If the non-custodial parent applies for a downward modification due to a decline in income, the court will be very conservative in changing the order. Any voluntary reduction in income by the non-custodial parent will be frowned upon, resulting in the denial of the request to reduce the child support. Even a reduction in income due to a refusal to work overtime will most likely result in the denial of an application for a downward modification for an order of child support. Child support stops when the child reaches the age of 21 or earlier if the child becomes emancipated. In New York, a child becomes emancipated when he or she marries, joins the armed services, or lives on his or her own and is working full-time. The non-custodial parent must apply for the termination of child support upon the emancipation of the child. A custodial parent can enforce child support payments. If the non-custodial parent refuses to pay child support, a court order or judgment for support may be enforceable by means of a wage deduction. Refusal to pay child support may also result in a lien being placed on the non-custodial parent's property. A party who refuses to pay child support may even be held in contempt and lose his or her driver's license or be imprisoned. Child support payments are not dischargeable in bankruptcy. Once an order for child support is made, it is very difficult, if not impossible, to change. Although there is a 30-day right to appeal a decision, the appeal is limited to the facts of the case. Accordingly, if a party said something that was not in his or her best interest or did not say something that the party should have said, such an error cannot be corrected on appeal. If you need an attorney in regard to a child support matter, call us toll-free at 855-625-0800 to schedule a consultation.